in the matter of petitioner Charles Paul Nerswick versus respondent Lindsay Ann Dineski. Ms. Dineski, please state your name for the record.
Lindsay Dineski.
Please raise your right hand. You solemnly swear to affirm any testimony you provide to the court today will be the truth and nothing but the truth.
I always tell the truth.
Sure. Here's a more polished and engaging rewrite of your introduction. Hey, everyone. Welcome back to the channel. Today's video is one you definitely don't want to miss. Remember a few months ago when I covered that sovereign citizen case? Well, we're diving back into that topic, and trust me, things have gotten even more interesting. Let me know if you want it to be more formal, humorous, or tailored to a specific platform, like YouTube Shorts, TikTok, etc.
Ms. Dineski, we had a bench warrant to issue for your arrest back in December 4th, 2003.
There was no proper service on that. I was never given any service on that warrant, so it's invalid.
So the warrant issued because you failed to appear
For a court that I never received any service on.
for the show cause hearing. I do see that proof of service.
I was in another state, so there's no way I received any proof of service, and you guys had my email and my phone number, and nobody ever contacted me, so this needs to be thrown out immediately.
So that's not how the court.
Yes, it's what the law says. The law says if I do not have proper service, it's an invalid warrant.
Sure. Here's a cleaner and more engaging version of that line. Toward the end of that video, Judge Martin mentioned that the next appearance would be before Judge Oakley. Now, I don't know if you guys remember Judge Oakley, but I've covered him before on this channel, and let me tell you, he does not mess around when it comes to sovereign citizen nonsense. Let me know if you want it to be more dramatic, casual, or punchy.
Okay, Miss.
Me under trial on this matter because I've never been able to present any evidence.
Be quiet.
This is my hearing, and I'm allowed to speak at my own hearing.
I have to let you know I'm arraigning you.
You're reading it on an invalid warrant. This needs to be dropped immediately. Is this an Article 1 court or an Article 3 court? Because if this is not an Article 3 court, you have no right to adjudicate anything to do with my liberty interests. And my children are my liberty interests, and they are my offspring. And this man attacked me, so this entire PPO is based on fraud and is void. So that not only can you not arraign me, but you need to overturn the PPO immediately.
So, Ms. Dineski, you were served on October 23rd, 2023. There was a show cause hearing for a violation of the PPO that occurred on December 4th, 2023. Just for the record, I have muted Ms. Dineski because she refused to be quiet.
You're not allowed to mute me at my hearing. Is this an Article 3 court or an Article 1 court, ma'am? You have to answer me. Are you an Article 1 judge? Because if you are, President Trump said that you are not allowed to hear anything to do with my liberty interest in his executive order that he recently put out.
All right. So
are you Article?
Is that you stopped Mr. Nerswick's mail? You were interfering with his mail, Ms. Nerswick, and wasn't able to receive his mail.
If you do not have a constitutional oath, then you have to recuse yourself immediately and let me have an Article 3 judge, because this has to do with my constitutional rights. And Article 1 judges.
So the court is in receipt of a customer information form that appears.
You do not consent to this PPO, and you must prove and show your oath.
USPS. At an address of 18337 Ewell Road, Belleville, Michigan.
I was not living there. I had been evicted from there previously in June, so there was no proper service.
The petitioner filed a motion complaining that you, Ms. Dineski, stopped his mail.
I didn't stop anybody's mail. He came and stole my mail and signed for a certified letter that he sent me, so I didn't receive it. And you guys won't let me show evidence. This has been going on for over a year, and I've never once been able to show evidence, and I've demanded a trial multiple times, and you've denied me a trial. So you're going to be going to prison under USC 18, 241 and 242, and I'm going to be asking for the death penalty for you.
Absolutely. Here's a more polished and YouTube-friendly version that keeps the energy and excitement while cleaning up the language. Well, today's the day, ladies and gentlemen. And wow, this might be one of the most epic sovereign citizen takedowns I've ever covered. We've got one of the most outrageous sovereigns going head-to-head with one of the toughest judges I've featured on this channel. And believe me when I say this, you have never heard a judge go off like this before. So, let's get into it. Let me know if you want to keep a bit more of the raw edge or tone it down even further.
Stand by.
Yeah, stand by. This is also a bill of payment and penalties, which has been outlawed by the Constitution, Article 1, Section 9, Clause 3. You are using an unlawful PPO to withhold me from my offspring, which qualifies as kidnapping and hostage taking and treason and torture. This matter is void ab initio from the beginning because it's based on fraud, and fraud vitiates everything. Marbury versus Madison, anything repugnant to the Constitution is void. This is a violation of my free speech. This is a violation of my right to petition the government for redress of grievances. It's a violation of my Second Amendment because you said I couldn't have a weapon or bear arms.
Ms. Danelski, I'm gonna put you in the breakout room with Ms.
This is a violation of my Fifth Amendment. This is a violation of my Sixth Amendment. This is a violation of my Seventh Amendment. This is a violation of my Eighth Amendment right, my inalienable Eighth Amendment right. This is a violation of my Ninth and Tenth Amendment rights. You are violating all of my rights, and I have not ever been allowed to be heard. Due process allows me the right to be heard, and this has been ongoing since 2023, and I have never had the right to be heard. And I've had my babies unlawfully held from me based on fraud, which I never got to present evidence to prove otherwise.
Sure, here's a refined version that keeps your voice and enthusiasm intact. I really wish more judges were like Judge Oakley. He cuts straight to the point, no time for games. Honestly, you could put his picture right next to no nonsense in the dictionary. And just a heads up, as this video goes on, things are only going to get wilder, right up until the very end. Let me know if you want a version with a bit more humor or intensity.
Okay, we don't have a prosecutor. I'm putting this over. I want to reconvene at 2 o'clock.
I'm demanding a quo warranto.
All right.
And I need
Deputy, did you hear me? Officer?
Your Honor, I do have a 2 o'clock. Did you want me to come back? I have a 2 o'clock in
I don't need an attorney. I don't consent to an
Yeah, I
attorney.
can't. I don't have a prosecutor. I need you to come back. What about 2:30?
I want to say something. You guys are. I've talked about
Your Honor, I'm talking to
5 days.
I
I've been
have
here for
no
5 days.
prosecutor.
I was not even notified of this court. I was not even given notice of this court date, and I've been here for
So
5 days.
let's say 1:45. I don't have a prosecutor.
You need to be quiet. This is my hearing.
Can we do 1:45, officer?
Yeah, 1:45.
Okay.
All right, we'll
I'll be
see y'all
back
back
at
at 1:45.
Okay, thank you, Your Honor.
I do have one question.
Go ahead, officer.
Just for staffing purposes, can you give a time, because that's right around shift change. Do you think that hearing would be done by 2:30, or are
I'm
we
waiting
looking
on a
at
prosecutor.
2:30?
I can't.
Well, it has
The
to
record is
Your Honor, I
going
have
now.
a 2
I
o'clock.
can't
I
call it.
need
So
a prosecutor. I'm asking for this to be
Okay.
dropped.
yeah, 1:45 is the time that I have.
Why
Okay.
won't you answer any of my questions?
Your Honor, I'll see you at 1:45. Thank
Sounds
you.
good.
You just ignore my questions.
Here's a refined version that keeps the tone, but polishes. The phrasing, I honestly don't need any more proof to suggest this guy's daily hobby might involve huffing duster. I mean, why on earth would you try to represent yourself in a criminal case when there's a perfectly qualified attorney right next to you, someone who spent more years in law school than you spent in the 3rd grade? Let me know if you'd like any further tweaks.
I do believe arraignments can take place without the prosecutor's office, but
I kind of
Must
thought
be
so. I
the-
did start, but for this particular one,
Yeah, this one, I think.
considering the fact that, you know,
Yeah,
I've been, this is, we needed you here. That's why I started off and I was like, oh no, let me.
Leslie, as far as the allegations go, I do believe that this is a bench-born arraignment.
Hold on.
Oh.
Yep, it is. Let me start to call the case. All right, CJC, are you there? I want to call the case, but I want to hear from you. Unmute.
Yes.
All right. All right. Thank you. Let me call the case.
Recording in
This
progress.
is case number 23-104850-PP in the matter of Charles Nurswick versus Lindsay Ann Dineski. Mr. Tudge, if I could get your appearance for the prosecutor's office.
Good afternoon, Your Honor. Gregory Tudge, P85961 for the people.
All right, Ms. Fort Williams, your appearance, please.
Good afternoon, Your Honor. Gail Fort Williams, P35963, counsel on behalf of Mr.
All right, Ms. Fort Williams, you had an opportunity to speak with Mr. Dineski in the breakout room.
Why is there still an attorney on my case when I said I don't want one?
I attempted to speak with her, Your Honor.
I do not want or need an attorney.
All right, Ms. Fort Williams, I just want you to stand by at this time, if you can do that.
And I'm entitled to relief from judgment under Michigan Court Rule 2.612 because I was not personally notified of this matter. And so it needs to be dismissed immediately.
Ms. Dineski, you were arrested for a warrant issue because of your failure to appear.
A failure to appear on something I was not personally notified on. So under Court Rule 2.6123, not personally notified, I am entitled to relief from this proceeding and action.
Okay, let me hear from Mr. Tudge. Go ahead, Mr. Tudge.
Your Honor, it does appear that the 2.512, I believe, was the citation, which 2.516.
No, I'm sorry, 2.612.
Chapter 2 of the Michigan Court Rules governs the civil procedures. This being a quasi-criminal matter,
This is a civil procedure because it's family court.
Hold on, Ms. Dineski, let Mr. Tudge speak.
It's not quasi-criminal, this is civil.
All right.
So that's a twisting. This is a family court matter.
Ms. Dineski, please let Mr. Tudge speak first, please. Go ahead, Mr. Tudge.
I thought this was my hearing. I should be the one speaking.
Mr. Tudge is from the prosecutor's office.
He doesn't need to be on this case because it's civil. Prosecution doesn't happen on civil cases.
Here's a more polished and sharp version of that. Do you, though? Because all I see is a judge who's clearly fed up with dealing with a complete nuisance. And this nuisance, well, he's about to find himself facing some jail time because he refuses to sit down and keep quiet. Let me know if you'd like to adjust the tone, or if you want it even sharper. Clips. Of course. Here's a more polished version with a bit of humor. Can we all just take a moment to show some appreciation for judges like Judge Oakley, who are masters at helping the troublemakers find out exactly what happens when you mess around? Let me know if you'd like it tweaked further.
All right, go ahead, Mr. Tudge.
Thank you, Your Honor. The MCR 2.612 does appear to be governing civil proceedings. This matter being a quasi-criminal proceeding does and is controlled by the court rules which address misdemeanor offenses, unless otherwise stated in Chapter 3 under special proceeding. I do believe that the cited rule is inapplicable for this proceeding.
You may proceed.
I'm sorry, I didn't hear him. Did he say applicable or inapplicable?
It is applicable, Ms.
Oh, okay.
Okay, go ahead,
Your
Mr.
Honor, I must correct the court. The argument is not applicable, inapplicable.
Oh, he said not applicable.
Why would it be inapplicable?
He's saying the court rule your side, his position, and I agree with him. Let me just say that for the record, that the court rule your side, it governs civil procedure. It doesn't govern under quasi-criminal matters.
This is not a criminal matter. This is a civil matter.
which
It's
is
a
why you're in
domestic,
jail.
it's a domestic matter. How is that criminal?
Ms. Dineski.
And in criminal procedure, it's the same thing. These also, the criminal code
Ms.
also.
Dineski,
The
you have to,
reason why, ma'am, the reason why I looked up the
I'll
civil
give
code
you
is
an
because it's a
opportunity to
civil-
speak, but I need to hear from Mr. Tudge first.
But it's my hearing. I should be heard first. This is
No.
my hearing. I'm the one who's supposed to be heard, not the prosecutor.
But they're being heard because you're violated a PPO.
I didn't violate anything. I was not
I'm
notified
sorry,
of
the
anything.
allegation that you violated a PPO.
Okay, well, then I have a right to say was not
I'm
notified.
going to give you that opportunity, but you have to, the allegation is that you violated a PPO. You have to let the prosecutor's office, the representative of the attorney from the prosecutor's office speak. Go ahead, Mr. Tudge.
Your Honor, I don't believe I have anything further as to the argument as it relates. I would ask that the arraignment for the bench warrant continue, and I would also ask that the court inform the respondent of the standards for which respondent will be held if proceeding pro se, and I believe it would be appropriate to.
I'm proceeding sui juris and persona.
Well, I am going to ask Ms. Fort Williams to operate.
No, I don't want an attorney. I do
And
not
my
consent to an
attorney, Ms. Dineski, I have acknowledged the fact that you are not wanting an attorney.
No, I refuse it. It's not that I don't want one.
I have Ms.
refuse
Fort Williams to stand by. She's just gonna stand by.
Even though I
What else would
appreciate
you like to say, Mr. Tudge?
I believe it may be of benefit for the court to voir dire or Attorney Williams to voir dire respondent as to a right to have counsel and whether respondent knowingly, intelligently, and voluntarily waives the right to counsel.
All right, Ms. Dineski, you
Your Honor.
understand? Go ahead, Ms. Fort Williams.
Your Honor, I just wanted to say, Ms. Dineski was speaking about being served with the violation, and she's indicating that she was not served. She may have been quoting the incorrect court rule. I don't know. I don't have the court rules in front of me. It doesn't matter, though. Either way, of course, anybody in court has to be served with the appropriate papers. What she is indicating is that she was not served. And I indicated to her, but I don't think she was listening to me because she was talking and I couldn't talk. I indicated to her that this is an arraignment and that she will have the opportunity to address service or lack thereof, if that is the case, when a trial is set or whatever is set.
No, according to Lufkin versus McVicker, I can challenge us at any time.
Your Honor, Ms. Dineski, you have to be quiet. For purposes of what she was indicating, Your Honor, it is true that everyone has to be served. I don't know about that court rule, and it doesn't matter whether she's quoting all these rules. It doesn't matter. She's indicating she wasn't served. That's all. Thank you.
Thank you. But the thing is that it doesn't matter if this is
Hold
an
on,
arraignment.
Miss. Procedurally, there are things we have to